Welcome. This presentation is available for MCLE self-study credit. If you would like to receive credit, you must take 3 actions. First, click Show More text below on our YouTube page. The text will expand and show a link to download the handout materials. Once you finish watching this presentation, please click the quiz link to receive self-study credit. Once the quiz is successfully completed, you will receive a certificate via email within 72 hours. We hope you enjoy the presentation. Thank you. It's my pleasure to now turn to introducing our fabulous panelists today. So starting with Michael Nebenzahl. Michael is a seasoned trial attorney with over 40 years of experience in civil litigation, including work as both a defense and plaintiff's attorney. Early in his career, he represented plaintiffs in personal injury cases before transitioning to defending public entities, municipalities, and transportation organizations in high-stakes litigation. He's litigated more than 50 trials, ranging from catastrophic injury claims to complex disputes involving dangerous property conditions and civil rights. Known for his professionalism, civility, and strategic approach, Michael's peers recognized his excellence and integrity through his election to a BOTA. And additionally, in 2009, the Daily Journal awarded Michael one of its top 10 defense verdicts for 2008 for his verdict on behalf of the Rose Bowl and City of Pasadena in the case of Morales versus Rose Bowl et al. As a neutral, now with ADR Services, Inc., he prioritizes preparation, respect, and creative problem solving to guide parties towards equitable resolutions. Thanks for being here today, Michael, and for putting this presentation together for us.
Thank you.
Our other speaker assisting Michael today and providing some dynamic color for this presentation is Justice Victoria Gerard Cheney. Justice Cheney is a highly respected mediator, arbitrator, referee, and appellate consultant with more than 40 years of experience. She served 19 years as a trial judge and was confirmed to the California Court of Appeal in 2009. And Justice Cheney is widely known for her intelligence, her judicial temperament, her thoughtful approach to resolving complex disputes, and today for being Michael's assistant in this presentation. So thank you both very much for putting this program together. It's been a delight to work with you, and I look forward to seeing what you put together for us.
Thank you.
All right, I'll hand it over to you now, Michael.
Great, thank you. Thank you very much. Good afternoon, everyone. Thanks for being here. Let's jump to our first slide, which is an introduction. Let me first let you all know, in addition to the materials that we've provided to you, Justice Cheney and I, our goal is to not read the screen to you, but to give you kind of a helicopter view, to give you our input and comments that go along with the materials and our slide presentation. So what we're going to talk about is the basics of how to bring a tort claim action against a public entity. And by brief background and perspective, this all started with the 1963 California Tort Claims Act. And we are guided by the code primarily from sections 810 through the 900s. It's a very specific set of rules and guidelines that oversee all of this with respect to bringing an action against a public entity. We're going to talk about the claims process, which by now most of you know, the filing of a claim or the presentation of a claim is the condition precedent to being able to pursue and file an actual lawsuit, the complaint, against a public entity. From there, that will be the bulk of what we talk about, this actual procedure and claims process. We'll also talk about the law that tends to apply in the government tort liability world, which is either negligence, and we'll talk about the distinction and what it is compared to dangerous condition of public property law. This is not going to be a case-heavy discussion today where we talk to you about Smith versus Jones or Smith versus the state of California. There are some cases cited in the materials, but this is really code-driven and an overview of this process of the practice, which is really about policy, rules, and procedures. I want to point out to you that the Bible is the government code. And as I said, it starts at section 810. It's not very long. And the commentary that many of you should know about that goes hand in hand with the code is now the CEB, Governmental Tort Liability Practice. It is the best guide and the best reference source out there for all of you if you have anything to find out about with respect to pursuing a public entity. The government code spells out the claims process in sections 900 to 913. We'll talk about that. How to sue and when to sue, that gets you to sections 940 to 948. When we talk about the rules on the liability of a public entity or a public employee, that's in the earlier sections, 815 to 823. The duty on a public entity, little important thing to know here, the duty to defend an employee if he or she commits a tort in the scope of their employment, which means as a practical matter, you don't need to name or sue the employee once you get to your lawsuit. The basic rules of dangerous condition of public property, of course, are found at 830 to 835. And then there's some more specifics within the code section, ranging from police and fire actions and medical hospital actions and more. But again, this is our overview of what we're going to discuss and what we're going to talk about today. Lastly, as an introduction comment about an overview, I want to point out to you that many of you are probably familiar with using the Judicial Council form complaint. That's almost demur-proof. It's a wonderful way to file a complaint, check your boxes, and you're covered. In that form complaint, the Judicial Council form complaint, you will find, I think if I recall, at the bottom of page 3, it might be box 10 or 12, I can't remember just now. You must check in that form complaint that you've complied with the claims process. And that's what we're talking about today, because it is a jurisdictional foundational requirement in order to proceed against a public entity. If you don't check that box, or if you don't allege it in a complaint, your complaint can be demurred to. And that just delays things. So this is a big picture overview. I hope that you get an idea now of where we're headed. We're going to talk about the process of claims. We're then talk a little bit about the distinction between a negligent action, a dangerous condition action, and then we'll talk about how they work together and finish it up with a few words on immunities. And so with that, we can move to our next slide.
Can I interrupt for 1 second? Can I just say something here?
Please add it. Please comment throughout, Justice Chair.
Okay, great. I will. I just wanted to point out that you might be wondering why we have government tort claims to begin with. It actually started in merry old England when there were two types of law. The church law that took care of your spirit, and then the law of the land or the law of the king. And you had to get permission from the king in order to sue. So although we don't have a king here, obviously, anymore in California, the idea that you get permission from the government to sue and you give notice to the government is where all this came from. I want to point out something that Michael said. I want to emphasize this. This is jurisdictional. If you don't do this, you are sorry out of luck. It is finet. It is over. So it is very important to make sure that you look into the idea of a government claim. If there's any chance you have an accident and a case come to you and you look at it and you wonder, is there a problem with the stop sign there? Or were the lights working okay? Or was the intersection designed properly? Or you have something happen on a sidewalk like a trip and fall? Think about, are you going to sue a government entity? And if you are thinking about suing, then you're going to have to follow the claims process, and you're going to have to do it in a timely manner. Thank you, Michael.
That dovetails with where we're going right now, which is a government tort claim required? And Government Code Section 905 is very clear. Any suit for money or damages requires a claim for damages to be presented to the public entity. It must be done before you can file suit. That rule in 905 is further codified in 945.4, which says no action can proceed without a claim for damages having been presented. So what we're talking about is if you want to sue, as Justice Cheney was talking about, the sovereign, the monarch, in this instance, a public entity, if you will, the code sets out the rules, the limitations, and the requirements, and it starts with the claim. And that claim must be timely filed within 6 months. The technical phrase is from the accrual of the cause of action. The practical reality in most tort actions is the date of the accident. And this is because the public entity, on behalf of the public at large, has to have the opportunity immediately. They've now extended from what was 100 days down to 6 months, but as soon as possible to investigate that claim and to be able to remedy or guard or prevent against future harm to other members of the public. And that's the reason that we have this short time limit so that the public entity can protect itself. And when we look later at late claims, it comes back to this very point, and that is whether or not the public entity has been prejudiced. So the claim has to be presented timely. They have to be on notice of what they're going to investigate, and they need to do it so that they won't be prejudiced. The code is very clear on this with respect to these processes. Sections 910 and 911.2 very clearly spell out where you must present the claim. Now, there may be some folks on this webinar that know me from my past practices, and I've represented a number of public entities. Some people from time to time wanted to present their claim to me because they know I represented city X or Y. That's the wrong place. The code is very specific. You must present it to, I think in the code it says the board. As a practical matter, it is the clerk for a city. It's to the clerk for the board of supervisors. It's all very clear with respect to who the claim must be presented to. The code tells you how the claim is to be presented. It tells you when it's to be presented, not later than 6 months from the accrual of the cause of action. And it tells you very specifically the contents of the claim. A minute ago, I used as an example and mentioned the judicial counsel form complaint. I want to encourage anyone who wants to proceed against a public entity to use that entity's form. Almost every city, county, state now has this online, of course. And when you fill out the form for that public entity, it is effectively demur proof. In the instance of the claim process, it is sufficiency proof. They almost would be in bad faith to send notice of insufficiency if you filled out the claim properly. And then, of course, once you've filled it out, it begins the process of what the public entity must do next, which Justice Cheney is going to talk about in just a moment or two. Justice Cheney, any comments at this point?
I have a couple. Yes, thank you.
Great.
If you think 6 months isn't enough, when I first started in law, it was 90 days. And so they extended it sometime after 2000, right, Michael? I think. Or late 90s. Anyway, they extended the time that you have to bring a claim. I want to point out that there are government entities that are not the normal kinds of things you think about. Normally, we think about a state, a county, or a city. But remember, there are school districts. There are air quality control management districts. There are hospital districts. So there are other kinds of government entities with which you might have to file a claim. So just be aware of that.
Thank you. And of course, utility there may be water districts, utility districts, and the like. And in today's world, of course, virtually every single one of them will have a form that is easily accessible. And they have a duty and responsibility, by the way, if you contact them because you can't find a form, if they have it, to provide it to you. The last comment with respect to it is you don't have to have a form, but what you must have is the proper contents as spelled out in the code, sections 9, 10, 9, 11, etc., so that the entity has the sufficient information that places them on notice of the where, the what, the who, the how, the why, what the claim is, and the damages and the like, so that they can then begin the investigation process.
Michael, may I add something here? If
Sure.
that's okay. Michael was encouraging that you use a form complaint. That's great, except if you have multiple causes of action in it and you can't use a form complaint because you're suing other people or you have unusual causes of action included. And so if you don't use a form complaint, remember you have to state in the complaint that you have filed a claim and complied with the Government Claims Act. I'm done.
Okay, yes, and that the critical phrase in your non-form complaint is that you have complied with the claim filing requirements timely, and then you're off to the races. So with that, let's move to slide 4, and Justice Cheney, you're up.
I want to add something to what Michael was saying. It isn't just a demur. Sometimes the public entity doesn't demur for whatever reason, and it comes along to summary judgment time or to trial time. And I actually did trials many years ago when somebody would come in and they would give their opening statement, and I would make a motion for a non-suit because they had not filed a government claim, and the case was over. So beware, please. It's really important. And with that, let's talk about once the claim is filed, what happens next? Well, Government Code Section 912.4 subpart A requires that the public entity act on the claim within 45 days. So if the government during that time goes out and investigates, allegedly, looks at things, they may contact the attorney for more information. And if you amend the claim along the way, that 45 days starts running again. So they have 45 days. The entity must also not only act within 45 days, but provide notice of the 6 months to file a lawsuit. So remember, please, that it is not a 2-year statute of limitations to file something as it is in a normal case. Like if you were in a car accident, you'd have 2 years to file. Here you have 6 months to present a claim and another 6 months maybe to bring a late claim, which we'll talk about later. But also you only have 6 months more to file the lawsuit after the rejection of the claim. So that's very important that you remember that. Michael?
Let me pick up on that, something that's very, very important. And of course, much of what we've said so far has to do with those lawyers practicing on the plaintiff side that need to present the claim. With respect to the public entity, there is a significant duty and responsibility on them to respond within their 45 days and to do it properly. Otherwise, there are serious consequences for the public entity. First and foremost is if they do not respond within 45 days, your 6 months to thereafter bring a suit does not exist because they've not given you notice of that 6 months. You now have 2 years from the accrual of cause of action, basically from the date of the tort, to file your complaint. In addition to that, the code is extremely clear and specific in what the public entity must and how they must give you that notice of what they have done, what their response is to your claim. And if they do not follow the statute and if they do not follow literally the language that is quoted in the statute, they may be giving you defective notice and they are probably going to have waived their defense to insufficient notice of the claim at that time and throughout the lawsuit. So the code can be very strictly enforced against a public entity, just as strictly as it can with respect to these time limitations on bringing the claim within 6 months. So, should we move to the next slide?
Please.
So now, this is something I had a lot of experience with over the years, and this relates. This is, what if your claim is late? The first thing I want to emphasize is when you proceed with what is seemingly, in colloquial phraseology, a late claim, you are not presenting a late claim. The code is clear. The process that you're going to follow is an application for leave to present your claim late. And what that means is you are not asking to file a late claim. You are asking and explaining in the process that you are late with your 6 months. You now have an additional 6 months to present your application. And as long as it's presented within 1 year, absolute outside time to present an application for late claim, the public entity then must respond to it, just as Justice Cheney detailed. The same rules apply with respect to the 45 days to respond to the application to be able to present the claim. Now, the application includes the proposed claim as an exhibit. The application must include additional exhibits that explain why you are seeking this relief, why you are not able to file the claim within the first 6 months. It needs to explain what the excuse is and what are the grounds, and that there's arguably no prejudice to the public entity, so that when the board or the clerk or the council governing body takes a look at the application, they then can decide whether or not to accept or to reject this application for leave to attach a late claim. Again, is presented to the same place. The rules are very specific with respect to the clerk, the county clerk for the Board of Supervisors, and so on and so forth. Your outside time limit is 1 year. That's the latest. It's the 6 months plus 6 months in order to present the application for leave to present a late claim. Now, want to emphasize, again, the rules are clear. You need to make sure that the application includes the new proposed claim as an exhibit. And when I point out that the claim at this juncture is a late claim, but it is not technically called a late claim. It's just after 6 months, and that's why they call it that way. And we know that because in the form or in the contents of the claim that you're presenting, you have to state the date of the incident. And on the face of it, it tells the board or the reviewing body whether or not it is timely within 6 months or late. Justice Cheney, any comments?
No, I think you've covered it all very adequately. Thank you.
Okay. Just remember, this is your opportunity to put your best argument forward in order to get relief with respect to being able to present that late claim. And now we'll go to the next slide.
And that is me. So let's say you presented a late claim and you have an excuse. The government must, I repeat, must grant the application under Government Code Section 911.6 subpart A if there is a failure through mistake, inadvertent surprise, or excusable neglect, and the entity was not prejudiced. So this is similar to the Code of Civil Procedure, where you come in and you say, "Oh, geez, I'm really sorry, I goofed. please forgive me. It's similar, but this code actually says the word prejudice. That is a standard that's also used by courts in the Code of Civil Procedure, but it is basically the same thing as the Code of Civil Procedure. Next, the government has to grant the late application if it's a minor. But please note that this means that if the minor turns to majority within 6 months, so let's say they're 17 and 3/4 when the accident occurred, if that happens, then the minor has 1 year to file a late claim, but there's no other tolling as provided by this for the status of the minor. Also, if the person is physically handicapped or mentally incapacitated or dies within the 6 years. So oftentimes you'll have somebody that was in a car accident and they've hit their head and they've been in a coma for a while. That's a good reason they're mentally incapacitated because they can't respond to anything. So it's a good reason why the government claims body must grant it. And if somebody dies within 6 months, so sometimes you'll have somebody have an accident and then 3 months later or 4 months later, they'll have a heart attack and pass away. That is another excuse. But I have a question for you, Michael. If there's no action by the entity during within 45 days after this, does that 2 years still apply?
It does not. Government Code Section 946.6, subpart B3, thank you for asking, says if they do not respond within 45 days to the application to present a late claim, you now have 6 months to file your petition to the Superior Court to now, through the court system, seek the same relief from your obligation to timely file within 6 months.
So what you're saying, Michael, is it's 2 years if the government fails to respond in the 45 days as to the original claim, and it's only 6 months at this time.
Yes. Now, you probably know this from having been on the Court of Appeal for many years. There is an awful lot of law out there, many cases with respect to late claim applications and petitions being granted or denied.
You can say that again, my friend.
and so the law that you'll see if you ever need it is basically the same standard from 473 in the CCP about mistake, inadvertence, or surprise. The difference is it is in conjunction with the need to also show no prejudice to the public entity.
Actually, Michael, that is a little bit within 473, but many people don't talk about it. But it's part of the code section here.
Thank you. Luckily, I haven't had too many of those cases over the years. Okay, so we're going to move on now to our next slide, which is tolling and minors. And this is a troubling subject, frankly. It's troubling because there's basically day-to-day no tolling with respect to the claim filing deadlines. This is not about tolling a statute of limitations to file the lawsuit. We are talking about the government code and presenting a claim in order to sue. So at a base level, you have to appreciate that there is no tolling for a minor. The rationale behind that is a minor has parents, and the parents have a burden and responsibility if there is an action that they need to pursue on behalf of their child, that they need to comply with the claims process in a timely manner. Now, there are some exceptions, and those exceptions are, and I think Justice Cheney mentioned some of them, if the minor was a minor within the 6 months, if the individual died within the 6 months, mental or physical incapacity, it's not necessarily technically a tolling, but it is cause and grounds where the public entity must grant the application for leave to present a late claim. And so there's a subtle difference in distinction but it is one that's important. There is a United States code that does provide tolling for those in the military. There are government code sections on this with respect to prisoners. They're technical. There's cases. What I want to tell you is there is a distinction between the tolling to bring a complaint as opposed to not the ability to toll to bring a claim on time. And so you're going to need to look at that depending upon the facts and circumstances of your case. And you need to look at those statutes closely and carefully. And as I say, they're all there in the government code in the 900 sections for you. Now, let's just talk about why. And Justice Cheney mentioned this at the outset. This is about the right to sue the public entity, the sovereign, the king, or the like. And so these procedures have been put in place because there are limitations on the extent and scope with which the public entity can be sued. And this is because when the public entity is sued, it is exposing the public treasury, our tax dollars, to exposure. And there are policy reasons behind these limitations. It is different than the tolling or the right to sue an individual where the harm is to that individual or business only, as opposed to the public at large. Justice Cheney, any comments there?
No, other than I agree with you.
Okay, I'm happy to hear that. Let's move on to slide 8, and I think it's up for you.
It is. It is. So what happens after the claim is denied or you have the late claim application that's accepted, and there's different filing times or deadlines. So if you have a timely claim, which I hope you do, and it's denied within the 45 days, you have 6 months in which to file your complaint. Again, remember, if the government forgets to deny the claim or sleeps on it or whatever, you have 2 years. But in this particular case, if you have a timely claim, you have to file with the court in 6 months. If the application for the late claim for relief is accepted, that would be like for a minor or somebody that's incapacitated, then the claim is deemed timely filed and the entity has 45 days to proceed, and then you have the 6 months after that. If the application for the late claim is denied, you have to file a petition with the court. You go to the superior court for relief within 6 months of denial. If you fail to do that, again, you're sorry out of luck. It is over. I think it's probably best to be cautious the minute you realize that there's a government tort claim that may be at issue, or that maybe you've forgotten about it, or the person didn't come to you in time. Act quickly, and that means file your complaint quickly. Don't sleep on things, because it ends your whole case. And with that, Michael?
Yes, there's a very, very important comment here to those of you that are practitioners in the plaintiff's world. And that is, when your case comes in the door, you are very, very concerned and mindful of your statute of limitations date. And it's relatively simple. If you know it's a public entity, you calendar your 6-month date. What's critical to understand and a challenge sometimes to implement is, once you get a rejection of the claim from the public entity at some date in the future, your accident is on January 1st, and you have 6 months to file your claim. Let's say you file your claim now on April 1st, and the public entity has 45
Hopefully you're
days.
not an April Fool, Michael, if you do that.
The public entity has 45 days to respond. And when they respond on, let's just say, May 1st, and they deny your claim, and they give you the proper language in the denial that you have 6 months from this date of May 1st to now file your lawsuit, that is your new statute of limitations date that must be calendared in your system, or you will be time barred from filing a complaint, and it will be a big problem. This 45-day response by the public entity triggers a new date. And if it's the application that's denied, as we discussed earlier, you have 6 months to file your petition. That 6 months is a new statute of limitations date that is triggered by the absence of the public entity responding, and it's 45 days from when it's deemed denied from when you presented the application for late claim. So you have to have your calendar, you have to have your support team, and you have to calendar these dates because they become extremely important and they are a moving target.
Michael, can I ask you a question?
Sure.
We've
I
been
have the answer.
I hope you do. We have the accrual date of the claim, so you just talked about January 1st. But let's say it's an accident case or a problem, somebody has an accident on a bridge, and it isn't until more than 2 years later that somebody raises the issue that maybe the bridge wasn't put together properly, has a bad slant on it, something. And all of a sudden you go, aha, maybe I have a claim against the government entity. Again, it's a couple of years on. So, Michael, can the person bring a claim at that time? Or is the person, again, as I said, sorry, out of luck?
Well, the short answer is sorry, out of luck. The long answer is that there may be some limited areas here. And part of what you're talking about really rolls into what many of us have dealt with over the years, which perhaps is a delayed discovery issue.
Right.
But that delayed discovery issue is very, very narrow in the claims filing arena. We're going to talk about med mal actions in just a minute and how they are unique with respect to claims and notices of intent to sue. But if you had an accident, what you're talking about is a theory as opposed to not knowing about the incident. And so you find out later. I actually had this circumstance, had this situation years ago. Automobile accident in a particular city. It was a serious accident. And 2 years later, in litigation between the defendants, one defendant, a light bulb went off and said, you know what, I've got a design issue with respect to this intersection that I want to cross-complain and bring in this city, because I now have a theory that they have a dangerous intersection based upon site obstructions or who knows what. And it was precluded from being able to proceed because the facts and the circumstances were there at the time of the accident, and the law firm didn't see the issue. And so that did not fly. And so I think that answers your question.
It does. So what you're telling us basically is something happens on a roadway, think all the possibilities at that time. And that type of thing is actually I've seen too, where somebody wakes up and goes, oh, there's a problem with the tree, or there's a problem with the way the bridge is designed, or there's a problem with the roadway making a left turn and isn't paved with the proper slant, et cetera, et cetera. So please, for yourself, think about the other possibilities.
And time permitting, with some of our later slides, that will come up with respect to multiple parties being sued. So you may have a roadway problem, and it turns out that maybe a private vendor was involved in building the roadway,
Yeah.
and you may not have known that, and maybe a bridge fell down or something was constructed improperly. And so you may have situations where you have the bridge is in the city or the state, and you proceed against the public entity. You may then find that there might have been a product liability issue with some steel that was provided, or you may find that there was some other tort by a new defendant. These are the hybrids and the challenges and the complications of multi-party, multi-issues, where you have to, with respect to a claim against a public entity, timely get that claim filed. Okay. Next slide is, I think I'm taking the lead on this. Justice Cheney, please jump in if you'd like. This is.
Oh, I'm not shy. Don't worry about it. I'll do that.
Okay, we want to run through this because there's some substance we want to get to before we end as well. So there are exceptions. There are always exceptions. We've listed, I think, many of the highlight ones. Inverse condemnation is under the California Constitution, so you don't need a claim. There's a specific statute with respect to school districts under 905.5 and asbestos. If you haven't, look at that code section, 905.5. There's a specific exception. You do not need a claim for the UC regents. There's a complicated exception with respect to the California State University system, whether it's an action in contract or against the trustees. That's under 905.9. Those of you that do employment work, FEHA doesn't require. And of course, those of you that can get involved in police and civil rights actions, 1983, they don't require claims. So with that, unless you have some comments, Justice Cheney.
I think you've covered them.
Okay.
Well, one thing, don't think exception the minute you look at something. Make sure that if you have a case against a government entity, then you file your claim. Don't think exception first.
Good rule of thumb. Let's move on now to the next slide. Medical malpractice actions against a public entity. What is the interplay between a notice of intent to sue letter and a claim that must be presented against a public entity? And they are entirely different animals. They have entirely different purposes. We've explained to you the purpose of the claim, which is to put the public entity on notice with respect to being able to prevent or remedy a situation and not expose others within the public entity to harm. That's an entirely different issue, or there's an entirely different issue with suing a healthcare provider or doctor and the requirement to proceed with a notice of intent to sue letter. And it becomes critically important because the notice of intent to sue letter under CCP 364 will extend by 90 days, can extend by 90 days your statute of limitations to sue the medical provider. Now, there are two cases in the materials. I don't want to talk about cases too much, but I want to point out to you. One is called Phillips versus Desert Hospital, which was a situation where the claim for damages was presented within 6 months. And did that extend the notice of intent to sue because the medical provider had been provided notice of the claim? The other case is Wirtz, and I apologize. I'm reading my notes, and the notes are Wirtz and Phillips. Phillips was the notice intent to sue case. Wirtz was the claim presented case. The point is, from both of these cases and for you, they are different animals. The notice of intent is to provide the medical provider notice with respect to his or her exposure, all of the issues related to that for medical provider with respect to insurance and reporting and the like. The notice requirements of the notice of intent to sue are different than the notice requirements of the claim. That's what these two cases point out. They are very, very different, and it's just important that you know that. You're going to have to look at those cases if you have statute issues that come up and you're concerned about, does the claim extend the 90 days or does the 90 days extend the claim? And the bottom line is, read those two cases. The notice of intent to sue is unique, and the cases that Phillips that talks about this puts a burden actually on the public entity to treat that notice of intent to sue as a claim, and puts the burden on them to give notice to the claimant if it's insufficient. And so very, very important distinction between the two. I also want to mention to you when we talk about professionals, again, the notice of intent to sue is different than the claim for damages, and they are both different when you want to sue professionals under CCP 411.35, where you have the requirement to, before you can proceed with your suit, for a certificate of merit. And a certificate of merit is not placing a public entity on notice of the claim. With that, unless you want to add something, Justice Cheney, I think that I covered the highlights there.
You have.
Okay, great. Now, moving on to considering a few other examples of situations. Of course, this entire talk is the tort action, and what about a breach of contract for money or damages? Briefly to discuss this, it also requires a claim because even though it's a breach of contract matter, if you're suing a public entity for money or damages, you need to proceed with the claim first. There's a specific statute that extends the time limit. And so if you are suing a public entity for breach of contract, it's not 6 months. Actually, under 911.2, it's 1 year. But I want to just briefly point out there's a statute set up in the California Public Contracts Code, section 9204. If you come across this situation, if you're pursuing a public entity on behalf of a vendor, someone with respect to a contract where you want to sue the public entity for money or damages, this code section is a process by which to help the vendors proceed informally, if you will, to collect on past due dollars when the public entity isn't paying because of all of the change orders and changes that take place throughout the duration of these types of contracts. What I want to point out to you is that exists. It is statutorily available between 2017 and 2027. I don't know if it's going to be extended, but most importantly, if you're in this situation, it does not circumvent the statute that requires to proceed with a claim, even though you've proceeded on these mediation processes with respect to collection on change orders. You still must present a timely claim, albeit within 1 year. So with that, Justice Cheney, let's now roll into a little bit of the substance behind all of these procedures of presenting a claim and now being able to file a suit. And there's basically two big umbrellas and areas that we'd like to point out to everyone, that there's the tort action under a theory of tort against a public entity and the dangerous condition. And I'll turn it over to you for the tort action.
Okay, I'm going to go through this quickly because we're getting short on time, Michael. So generally, under Government Code Section 815.2, if the injuries are by an employee of a government who is in the course and scope of his employment, then the government public entity is liable. But they're not liable if there's an immunity. So be aware of that. The public employee, if the public employee is liable for injury caused by his act or omission, then it's to the same extent as a private person. And he or she has the same defenses that would be available if they were a private person. And finally, a public entity is liable for an injury caused by a tortious act or omission of an independent contractor. So, for example, if you have somebody that paved a road and you're driving along and all of a sudden there's a sinkhole in that road and your car hits the hole and your car veers out of position and you're hurt, that would be a case not only against the government entity, but also against an independent contractor. And Michael, I'm going to let you pick it up from here. I just wanted to go through that quickly because we're getting short on time.
Okay, I want to make a couple of quick comments here. So many public entities that get sued for negligence, It's not common law negligence. That negligence, as Justice Cheney just mentioned, because of the negligence of an independent contractor that performed work negligently, or very frequently, it's by an employee who is in an automobile accident or a truck accident or a bus accident or any type of accident where the motor vehicle that they're operating gives rise to a motor vehicle negligence action against the public entity based upon the torts of its employee. And as I mentioned earlier, the employee does not need to be named in that suit because public entity is, by code, responsible and liable for the torts of its employees. And we mentioned in the materials and in the slide here that if you're dealing with these negligence concepts, the appropriate CACI instructions apply to each of those different negligent actions. Again, with the premise that you've timely filed your claim and then you've proceeded timely with your complaint.
Michael,
Yeah.
may I just add one other thing that I forgot to mention? Please forgive. There are no punitive damages or exemplary damages against a government entity. So you cannot say, send a message to City Hall, give us an extra million or so just to punish them. Please remember that, because that can cause you a mistrial.
And just a quick footnote, this discussion today is limited to the government tort liability practice. We've mentioned some exceptions, so we're not going to get into police civil rights cases. We're not going to talk about Monell and where there may be excess dollars under those circumstances. Under Government Code Section 818, no exemplary punitive damages against a public entity. With that, we'll now move into the big picture of what if the tort is a dangerous condition of public property? And of course, this is pretty much the bread and butter of a claim that's brought against a public entity. Whether it's a trip and fall on a sidewalk, whether it's a signal malfunction, whether it's a roadway defect, whether it's a site obstruction, you now are going to proceed against the public entity on your theory of a dangerous condition of public property. You filed the complaint. Before that, you filed the claim and gave appropriate notice of what your theory is and where this incident occurred and what was the origin of the cause. The signals weren't working. The stop sign had been knocked down, and so on and so forth. And so the basic rules of thumb here are exceedingly clear. They are specific. They are detailed in the government code under 835 with the elements of dangerous condition liability. Section 838 defines what a dangerous condition is. And these statutes are almost verbatim in the CACI Instruction 1100 series. And so what you'll come across is, does the public entity own and or control the condition? I want to point out to you, ownership or control can be dual, and it can be dual between a public entity as well as a private. Quick example, tree in the front yard causes a lift on the sidewalk. The private owner owns the tree. The city owns the sidewalk. You've got dual ownership and or control. And that dovetails to the second element, which is that is there ownership or control of the property or adjacent property of the condition that causes arguably a substantial increased risk of harm to a foreseeable user.
Michael, can I just add another example that's a common one? You'll often see in business areas where a business owner has put a beautiful colored terrazzo walkway or from their building out to the street. Terrazzo is lovely, but it's very slippery in rain. That is a situation where you have dual control or ownership, where the government entity owns the sidewalk. However, gee whiz, the owner of the building next to it has changed the sidewalk character.
And they may have violated a rule or two or code or two by not getting a permit because the public entity may or may not have known about that or approved it. That dovetails to the next element, just to briefly touch on, which is notice of the dangerous condition. So if the private entity changed the sidewalk, or if a homeowner put stepping stones through the parkway, does the public entity have notice of the condition? Most of you are aware of the concept of actual or constructive notice. So the public entity either must have actual or constructive notice. Constructive notice is a great phrase. I've loved it for many years. It means you didn't know it, but we're going to deem that you did know it. Now, critical here is the notice concept with respect to a public entity can also be imputed to them by the negligence of an employee in the course and scope. Quick example. Trash truck driver turns the corner and takes down a stop sign. 30 seconds later, 5 minutes later, however long later, somebody runs the stop sign. Well, there's no stop sign to run. It wasn't there to see. The public entity clearly doesn't have sufficient opportunity to have actual notice of it or even constructive notice of it. But because an employee in the course and scope caused that dangerous condition, that becomes the element of notice. And so that's important to know. And of course, lastly, with respect to this picture of dangerous condition, there's the necessary elements of causation and injury. And we pretty much assume those as we have this discussion. And with just a minute or two left, I want to briefly say there's nothing that precludes in the next slide. Thank you. There's nothing that precludes alternate theories of liability. There's nothing that precludes multiple parties. There's nothing that precludes all of those together in one lawsuit. But you still have to timely proceed under the government code with respect to those claims for money or damages as to those causes of action against the public entity. And you still need to proceed timely against the private entities with respect to the statute of limitations on those actions. And critically, when we have multiple causes of action and multiple parties, it is frequent that cross complaints surface. A quirk, and it's in the law, is if the public entity as a defendant, bless you, chooses to file a cross complaint against a new party, that new party does not have to file a claim against the public entity when they're entitled to bring a cross action, because they've been brought in by the public entity, so it knows who they are, they're on notice of it, they've waived the need for that. However, if you are a defendant in a multi-party action and the city is a part of that action, or you're going to bring them in that action, or any public entity, that defendant must proceed with a claim timely before they can file their cross complaint. And when are they, what is the accrual of their cause of action? Because they're a defendant, it's when they are served with the complaint. That is the accrual of their exposure, and that begins their 6 months of when they can bring a cross complaint. With that, Justice Cheney, I will leave you to a quick comment or two on immunities, our last slide, as we're just about out of time.
We are. Everybody, just remember that there are immunities for different actions of, I promise to be fast, Katie, I promise, for government, when you sue the government. They are found not just in the government code, but they are in many other codes, such as the vehicle code and the health and safety code. So you might want to be aware of those. And with that, thank you, everybody.
Thank you for that quick little wrap up there. Perfect. I do want to note that our speakers have both been generous enough to put their email addresses in the materials if you have follow-up questions for them. We are at the conclusion of our hour here, but I see that we have racked up quite a few questions throughout the program, so we will take a few minutes to respond to some of those. If you do have to head out for the afternoon and get back to your work, that is A-OK. You'll receive full CLE credit. As a reminder, your CLE certificates will be sent out within the next week, likely sooner, via email. If you don't see a copy, go ahead and take a look in your spam or junk filter, just in case they were caught there. I will drop a copy of the materials into the chat once more. We will also send those out along with your CLE certificates, so you can receive a copy there I don't know, there was a lot of content covered. I encourage you to take a look at the handout attachment, especially, which has a lot more detail than the slide deck was able to include. As you do exit the webinar, if you have to head out, you're going to be directed to a short survey. We really appreciate if you take a couple of minutes to fill that out. Let us know how we did, and especially any thoughts on future programs you'd be interested in seeing from either Michael, Justice Cheney, or any of our other panelists. We do always strive to give you programming that you're actually interested in learning about as you accrue CLE certifications here. So I will now turn to our pretty extensive Q&A section here. We had a lot throughout this program, so I'm glad that everybody was very, very engaged. We had a lot of questions about kind of the timeline, which you went into in some good detail there, Michael, but we had some specific questions about the denial process and how the date was calculated. Do you mind going through that once again, just in case anybody missed that?
Sure. The code states when you present your claim, the public entity must respond within 45 days. And they must respond in writing, and they must acknowledge that they received the date on X date, and they must state whether or not all or a portion or none of the claim is being accepted. And then they must tell you in clear language that is in the code itself that they must put in their written notice that you have 6 months from the date of this notification. And so what that means is you really have to follow when you presented the claim and when they respond. So if they respond to your claim within 10 days, and that 10th day happens to be June 10th, then you have 6 months from what is now June 10th to timely file your lawsuit. If they respond on July 12th, you have 6 months from July 12th to respond to that and to timely file your lawsuit. And so your statute of limitation date is entirely dependent upon the date that the public entity gives you proper notice. If
Michael,
they don't respond, that's when you are triggered by having a 2-year statute of limitations from the original date of the tort. We call the accrual of the cause of action, which in almost all of our instances in the tort rule becomes the date of the accident.
Michael, I've seen situations where the government entity responds, denies the claim sometime outside the 45 days, let's say day 53. What happens then? Is it 2 years or is it 6 months to respond?
It's 6 months from when they have rejected and given you notice and given you time when to proceed.
So even if it's late notice, it's still notice.
Yes.
And how long does the government agency have to deny the claim before it's deemed denied?
That's the same 45 days.
Okay.
And let me do a quick footnote, even though you haven't asked me. So on the application timeline, again, once you present your application for leave to present a late claim, whatever that is, it's sometime after 6 months and before a year. Whatever it's dated and it's received, it's the mailbox rule. So when you send it to them, they have 45 days to respond. And we're back to that same issue because their response obligations are identical. So your 6 months to file a petition, if it is from their denial, whatever that is. And if they don't respond, it's deemed denied on the 45th day, and you have 6 months to file the petition from that 45th day.
Question for you, Justice Cheney. What are some of the common types of government claims that you saw on the bench, and how often do you think it was that you saw people not timely filing those?
Probably the most common one was a dangerous condition, followed not too far behind by accidents. And dangerous condition claims sometimes are not known about. That's one of the biggest problems. That's why I said if you have something that happens on a street or a government property, please, please, please think about giving them a claim. You don't have, if you decide there's no negligence or no wrongdoing by the government, that doesn't, you don't have to sue them, but you have to bring that claim in order to be able to sue them. But most of the time, it's been dangerous conditions of public property while I was on the bench. While I worked for the city of LA as an assistant city attorney, I saw a lot of accident cases, auto accidents, and slip and falls are part of the dangerous condition, by the way.
Michael, you mentioned the complexities when there's several different parties involved. What happens if somebody submits a claim to an entity like the state of California and only mentions one department, but not another, like Caltrans, for example? How do they go about, finding out which departments are involved, properly serving notice? What happens if they miss one?
I think that's an easy answer. You're not suing a division or department A or B. You're not suing Caltrans or Department of Transportation or Department of Engineering or Department of Public Works. You are suing the state of California.
The whole entity.
And so the claim needs to be presented to the recipient on behalf of the state. And the details are, is it a public works case? Is it a roadway design engineering case? Is it some other department or within the state? So it is it's the state that you're suing, and that makes it easy because it's really only one claim.
Great. And in relation to like an employment dispute, are you required to name any particular individual defendants or just the state?
So I'm not sure if the question is a FEHA question under those statutes and rules and right to sue letters and notices and the like. But let me answer what I think is the question and what I tried to convey. If you are suing a public entity for an alleged wrongdoing, act or omission toward impropriety of an employee, for actions they took within the course and scope of their employment, you sue the entity. Ideally, you will name within the facts of your claim and within your complaint the who did the what, how and when they did it. But you need to pursue, and it's a pursuit against a public entity. Bear in mind, be cautious as you proceed with employment actions with respect to all of those timelines that are different timelines. They were not part of this discussion today with respect to the claims practices.
Mhm. We do have some other questions that are fairly particular about a specific set of facts, so I won't get into those in front of the whole organization here.
May I just add something about, you brought up the idea of multiple claims or actions. You can have a police case that is a police abuse, and that by itself is a state cause of action. And then you'll also have within it a 1983 cause of action. So you can have, which is civil rights violation. You can have a situation where there's no claim that's been filed, and the police abuse in the state action, like assault and battery, is thrown out, but you still have the 1983 cause of action because that does not require a claim.
Let's do one final question because we are getting to the 10-minute mark here. But does filing a federal lawsuit without a claim being filed subvert the claims process?
Well, I'm going to say three things. This is about California, not federal. I have not come across that situation. And lastly, the government code's clear. If you have an action against a public entity under the umbrella of the state of California, state, county, city, districts, whatever is a public entity, then you must put that entity on notice with a government tort claim under the California government tort claim statute. And I would not rely upon any other compliance. just as I wouldn't rely upon a notice of intent to sue meeting the claim requirements, even though that's still within the state of California.
ADR Services, Inc. has been your unwavering partner in alternative dispute resolution. But as the world changed, so did we. From virtual and hybrid hearings to our ongoing on-demand CLE program, ADR Services, Inc. continues to keep resolution and legal education at the forefront, woman-owned and operated from the start. There is someone for every situation. We are ADR Services, Inc.